In 1973, Congress pushed through legislation over the veto of President Richard Nixon, the War Powers Act, which, in a nutshell, Lou will get more technical about it, but from my memory, it was, look, President we look at ourselves in the Congress, and we're not over playing our cards here, but we're gonna say, before you do anything and declare war or do anything like a war, you've got to get the blessing of Congress to declare war. And if you don't, and you start hostilities within 60 days, you've got to stop. And oh, by the way, when you start those hostilities, you have to notify us about those hostilities. I think it's within 48 hours or something like
Right.
that.
Right.
And quite frankly, since 1973, both political parties have kind of disregarded it over time, as we've talked about.
Pretty much.
So, but now it's being raised again. It's actually legislation. It's on the books.
But that's the thing. It's legislation on the books, but there's also been challenges. And it's something that people have talked about where, is this constitutional?
Right.
It's law that's looking to limit the authority that's inherently in the Article 2 powers of the president. And that there's been other cases which have challenged the president and his authority to take certain actions prior to the passing of the War Resolution Act, the War Powers Act, where you had cases like the one was a prize case where it was challenged President Lincoln back in 1863, where it sort of said what was that they challenged his ability to do certain things regarding the railroads and other things like that, and that the court. I'm checking this because I want to make sure, I'm reading it from here, so I'm not misstating it, but that the court distinguished defensive responses to rebellions that are permissible under Article 2 from the offensive initiations of war requiring Article 1 actions, Article 1 authorization. So that's where they first started looking at it and started saying, here's what the differences are. But they found in favor of President Lincoln saying, yes, you have the authority to repel rebellions, put down rebellions, but also repel invasions. And that's something that becomes later on comes up in. Then one of the pivotal cases is the Youngstown case, which again, in our Article 1, Article 2 discussion that we have, Rob goes into it fully to explain it because that's a very pivotal case. Without going into all of it, the one thing that the Youngstown case says is that basically the court looked at it as a 3-level type of review, where level 3 means that, level 1 is when the government is operating fully in concert, that Congress has blessed the president's actions. And so that's when he's the strongest, and that it's very difficult to overturn what the president is doing.
Right.
The level 2 review is that Congress may not agree with it, but the president is sort of going on his own. They're not agreeing, they're not disagreeing, but the president is doing this. Then the third level, the lowest level, where it's like really more easy to overturn it, is when the president is acting in contravention of Congress. And it's important because at this point, we're sort of in that, what you could say is a level 2, level 3 type of review. But
also just remember that the Youngstown case was specifically regarding executive orders that are written out. But go ahead.
No. So some of the key things and some of the things that we'll discuss a little bit more fully in a second is the one thing that differentiates it, and the one thing that really is I'm going to use it, but I hate, is the trump card here.
You went there, you did it.
Yep, I did. Is that what people are overlooking also is back when, after 9/11, Congress did actually pass another law, and it was sort of a codification of executive order, the authorization for use of military force.
Yep.